If you're gonna shut your door.
Please. Can everybody hear me? Ms. Pritchard, can you hear me?
Your Honor. Yes, Your Honor. Are you able to hear me?
Yes. All right, we're on the record in 20 CPR 035111, the state of Deborah Miller. All right, we're here for a motion for clarification. And then, of course, we have a motion to disperse, release, withdraw funds, motion to deposit funds into the registry of the court. So I tell you what, let's start with this motion for clarification. Ms. Pritchard, go ahead. You have 5 minutes. I've read your motion, but you have 5 minutes to make your argument. Ms. Pritchard, you there?
Thank you. Yes, I'm here. Can you hear me, Your Honor?
I can hear you now. Yes.
Okay. Thank you. And Your Honor, it appears that there does to be a
Pritchard,
little
you have a
freezing on
really
this.
bad connection.
Can the court still hear me?
You're freezing up here and there.
Yeah, you have a really bad
Your
connection.
Honor. Okay, Your Honor, I'm going to relocate a little bit and see if I can improve that. I'm going to go to a different location and see if that will perhaps improve the signal. Can the court hear me any better?
I can hear you just fine now. Yes.
Okay. All right, Your Honor. And okay, then if it please the court, basically what we are here for today, as the court is aware, we have the estate owns a 50% undivided community interest in property located in Wimberley, Texas, and that's located at 44 Brook Meadow. This particular property has been listed as the only, actually the only basically left in the estate. This particular house has been listed for sale for 9 months since March of 2022. It went through a number of price reductions and did not receive any kind of offers until 9 months later in December. Mid-December was the first offer that it ever received for a quick cash sale. And the independent executive feels like this is a good offer. It's basically the same amount as what the appraised value, tax appraised value is of the property that the estate has a 50% interest in. The title company has, of course, reviewed the court pleadings, and they feel that the motion for removal that was filed by Mr. Miller, that constitutes a will contest, and they have been unwilling to issue title insurance and move forward to closing on the sale, which is actually scheduled to happen today. And they've been unwilling to do that unless there was either some type of court order confirming the executrix's power, to sell this property, or if Mr. Miller would agree. I did reach out to opposing counsel and Mr. Miller through his counsel to see if they would agree to the sale, and received an email which said that they were, unwilling to. So what we're seeking today from the court is a confirmation of the executrix's power of sale. And this is something that was expressly given under the will, because this is an independent administration, and it was expressly granted to the independent executrix under Article 2.1 of the will. In addition, the Texas Estates Codes, there's several provisions of it. And I apologize, Your Honor, since I've relocated here, I don't have those numbers sitting right in front of me, but it's in basically section 402, several different articles which provide the exact same thing. The will also confers upon the executrix the power of sale authorized under the Estates Code and under the Texas Trust Code or Property Code. So all three of the various statutory provisions, which are recited by statute number in the motion, they clarify those as well as the will. So that's all that we're seeking today, is just a confirmation of what her powers are under the will and by statute in the form of a court order.
Ms. Wild.
Judge, we don't oppose the sale, but it's what happens to the money. And you can see from the motion, there's intent to not follow the will. And that's the concern, is that until this is resolved regarding removal, that those funds be placed in the registry of the court.
Well, let me say this, Ms. Pritchard, it's highly unusual for me to step in after a independent executor has been appointed, or executrix, especially under these circumstances where I honestly, I've never had a motion to clarify your powers, essentially. However, I understand also the circumstances we're under, where we have a motion to remove the executrix as well, and there's some allegations that have been listed out. Are you opposed, Ms. Pritchard, to placing the funds into the registry of the court until case is resolved in February?
Your Honor, at this point, I don't have permission from my client to do that. And what I would comment with the court, it is an independent administration. The problem is that with putting the money in the registry of the court, the estate is handicapped. It's not able to continue to operate. It can't pay the bills that are coming due. There's still things which are having to be paid. The estate has had to borrow money and does not have any ability to pay that money back at this point in time because there has been no cash. So there's and I actually had made an offer to Ms. Wild to to at least fund a portion for a trust for Mr. Miller. This is obviously, these are things that are under the will. Mr. Miller does not have an interest in this property per se. What he has is a residual 50% interest under the will. And right now, there's a lot of bills that need to be paid. There is a couple of claims against the estate as well. And these are things that need to be resolved. And it's, this can't happen if the money is in the registry of the court. And again, I think as Your Honor, as you pointed out, there's an issue, really in an independent administration as to the court's jurisdiction. I was very hesitant to bring this motion as well, Your Honor, but the title companies.
Technically, under independent executor, I am to take no further action.
That's correct, Your Honor.
I personally, I'm hesitant to even sign off on something along these lines.
And I can certainly understand the court's reservation. It's an argument I've been making on deaf ears with title insurers. And it's what I can say, and I can certainly offer today, if Ms. Wild's client would consent to the sale, I think that the title company is willing to go forward with it. And I can assure them that they're not going to, that everything is going to be done absolutely in accordance with the will. We would still be willing to fund a trust for Mr. Miller to at least get this process started. There's never been any intent not to. It's just that there hasn't been any funds to do that with.
Ms. Wild, anything further?
Judge, we've received evidence through tax documents that the executor has lent herself $87,000 from a company that is part of this estate. We have a lot of concerns about that management. That's why we filed that removal. And so we can't agree to say, here's more money for you to pilfer through and mismanage. And there's still not a trust set up. That's the other factor too, is that we know from tax filings that testamentary trust, which should have been set up, hasn't been set up. So we would not oppose the sale if the funds go in the registry of the court. That's where the concern comes in, is what happens to that money once it's in her hands, as we've seen the other assets, which apparently they're saying there are no assets. And we also haven't received any of these claims that we've asked for in discovery. We've asked for what the debts are, and we haven't received anything that gives us some sort of concrete, this is what they're talking about. There's nothing out there that we have.
Anything further, Ms. Pritchard?
Nothing further, Your Honor.
I understand you have a closing today, but I'm going to tell you right now, I'm going to have to truly think about this one, because I typically don't take any further action on these independents. And I don't know if I'm willing to sign off on this order, because I'm sitting here reading it right now and it causes me pause.
And as I say, I can certainly understand the court's position on that.
I'm going to
There's some case law that does give courts some limited ability, to make clarifying orders.
I'm going to consider everything that was stated here, take it under advisement. You might want to push back your closing today because I don't know if you're going to get a decision from me today. I'll tell you that. I'm going to consider everything that was taken here today. I suggest y'all both talk and see if y'all can't work out some kind of arrangement prior to my decision. Anything further for the record, Ms. Pritchard?
No, Your Honor, and thank you. And I do appreciate the court's willing to accommodate us this morning on the short notice hearing.
Ms. Wild, anything further for the record?
Nothing from me, Judge. Thank you.
Thank you.